This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why double jeopardy eliminated 3 of 4 convictions for an insurance fraud perpetrator, although the Court of Appeal allowed a single insurance fraud conviction to remain. In the People of the State of Colorado versus Natasha Earnce Robinson, an October 27, 2022 decision of the Court of Appeal, prosecutors found that they overcharged a defendant, but her conviction for insurance fraud remained. Natasha Earnce Robinson appealed the judgment of conviction entered on jury verdicts, finding her guilty of 4 counts of insurance fraud and 1 count of false reporting to authorities. She contended, among other things, that because her 4 convictions for insurance fraud were based on a single insurance claim, those convictions are multiplicitous in violation of double jeopardy principles. To resolve her appeal, the Court of Appeals addressed an issue of first impression in Colorado and held that when a defendant is convicted for 1 count of presenting a fraudulent insurance claim and for 1 or more counts of making false statements in support of the same insurance claim, the prohibition against double jeopardy and multiplicity will generally require the conviction or convictions to merge. In this case, the insurance fraud statute, the complaint, and information filed by the prosecution and the evidence and argument presented at Robinson's trial all supported the conclusion that her 3 convictions for making false statements must merge into her 1 conviction for insurance fraud. According to the prosecution's evidence and theory of guilt, Robinson purchased a car but did not initially buy insurance coverage for it. 2 weeks later, Robinson's boyfriend and cousin were driving the uninsured car and knocked over a stop sign, causing heavy damage to the car. Later that day, Robinson bought insurance coverage for the car. A few days later, Robinson reported to the police that her car had been stolen and that it had no prior damage. She also filed a claim for insurance coverage based on the alleged theft. During 2 recorded telephone calls with her insurance company, as well as 1 recorded telephone call with a police detective, Robinson lied about her car being stolen and not knowing who took it. She repeated those lies in the affidavit she submitted to her insurance company. Following the trial, the jury found Robinson guilty of 4 counts of insurance fraud and 1 count of false reporting to authorities. The trial court entered judgment of conviction and sentenced Robinson to concurrent terms of 3 years probation. Fairly kind conviction and sentence, and yet she appealed. Robinson contended that her 4 convictions for insurance fraud were multiplicitous, in violation of double jeopardy principles because they are based on a single insurance claim. The Court of Appeal agreed. Whether convictions must be merged because they are multiplicitous, in violation of double jeopardy principles, is a question of law. The double jeopardy issue presented to the Court of Appeal was whether Robinson's multiple insurance fraud convictions were based on alternate ways of committing the same offense. The district court addressed the very issue, concluding that the offenses were separate, although it ultimately ruled that concurrent sentences were appropriate. Unless a statute expressly authorizes otherwise, the double jeopardy clauses of the United States and Colorado constitutions protect against multiple punishments for the same offense. Multiplicity may implicate double jeopardy principles if a statute creates alternate ways of committing the same offense. In these situations, whether multiple punishments are permissible entails a determination of the legislatively prescribed unit of prosecution. The unit of prosecution is the way a criminal statute permits a defendant's conduct to be divided into discrete acts for purposes of prosecuting multiple offenses. To determine the unit of prosecution for a particular offense, the Court of Appeal looks exclusively to the statute defining the offense. After determining the statutory unit of prosecution, double jeopardy analysis requires the court to consider whether the defendant's conduct constituted factually distinct offenses, that is, whether the conduct satisfies more than one defined unit of prosecution. Robinson's 4 convictions for insurance fraud were found to be multiplicitous in violation of double jeopardy principles, and that her 3 convictions for making false statements under Section 18.5.211 must merge into her 1 conviction for insurance fraud. The insurance fraud statute requires that when a number of acts are joined as a disjunctive series in a single sentence, without any attempt to differentiate them by name or other organizational device, a legislative intent to permit separate convictions and sentences for each enumerated act is not so readily apparent. To the contrary, by joining alternatives disjunctively in a single provision of the criminal code, the legislature intended to describe alternate ways of committing a single crime, rather than to create separate offenses. Robinson's was based on her presenting an insurance claim that contained false material information. Her 3 convictions under a different section were based on her presenting 3 statements containing false material information in support of the insurance claim. Robinson's false statements were part and parcel of her fraudulent insurance claim. Robinson's 3 convictions were based on 2 telephone calls with her insurance company and an affidavit she completed for the company. But what if the insurance company had a more exhaustive process that involved more telephone calls and more forms to fill out? All those countless communications would lead to countless convictions while still being based on only 1 insurance claim. The issue before the appellate court was distinct from a multiplicity issue that arises when a statute defines a crime as a continuous course of conduct. Third, the way the prosecution presented its case at trial supports the decision. Notably, the prosecutor began his closing argument by emphasizing that Robinson made the same false statements over and over again on call after call to get insurance coverage for her car. The prosecutor added that Robinson told the same story in her affidavit. In rebuttal closing, the prosecutor stayed the course, arguing that Robinson repeated false statements to her insurance company. For all these reasons, the appellate court concluded that the district court erred by entering judgment of conviction and sentence on multiple counts of insurance fraud, and then Robinson should stand convicted of just 1 count of insurance fraud under the statute. The judgment was therefore affirmed in part and reversed in part. Robinson's insurance fraud conviction was affirmed. Robinson's 3 insurance fraud convictions were reversed, and the case was remanded for the district court to vacate those 3 convictions and sentences. Although the jury found Robinson guilty of the defense of proposed lesser non-included offense of false reporting to authorities, the conviction does not appear on the district court's sentencing order, and to the extent Robinson stands convicted of that offense, she does not challenge that conviction on appeal. So she eventually was convicted of 1 count of insurance fraud and 1 count of false reporting to authorities. In my opinion, there was no question that the defendant committed insurance fraud by insuring a car after an accident and then reporting it stolen to collect, even though it was damaged before the policy came into effect. She lied to the insurer and the police with alacrity. Regardless, she only committed one crime, one insurance fraud, and she only committed one false report to authorities, and the charge of additional counts for false statements made in the presentation of the false claim was surplusage and duplicitous. Her sentence was for probation, and she stood convicted of 2 crimes, not 4 or 5. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the link zalma.com/blog. You should consider subscribing to the blog so that you can learn about every blog posting every day. And you should also subscribe to my YouTube channel and my Rumble channel where these videos appear. And if you find the videos interesting and useful, please click on the like button or the Rumble button and tell your colleagues so that they can also appear and subscribe to the blog and the videos. Thank you for your attention.